Welcome back, folks. Things are getting intense in Judge Washington's courtroom today. A standoff is brewing as a tenant digs in their heels, refusing to move out, even though the rent hasn't been paid. Let's unpack the drama and see how it all plays out.
The court will call the matter of the Ranchers of Rosebrook versus Anise Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
My name is Anise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is case number 25-CV-11. I object to these proceedings in jurisdiction, subject matter, and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of you have...
I object. The court cannot declare its own jurisdiction to respond to it.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers.
Nor facts, just as you don't, of why you have jurisdiction.
Honestly, if the court didn't have real authority, why even bother showing up? If I ever got a sketchy summons, I'd just pass it to my lawyer and keep it moving, no stress.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, actually the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you
That proof of service.
with respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201D, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a In addition to that, Ms. Battle showed up to the court respect to jurisdiction. We addressed that at the last court hearing. This is in Russell Court. Which has been noted and reserved. Do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Material breaches that's inside the contract.
Material,
That contract has not been
you said material.
breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract. Unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I and by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, an individual. Michigan, you still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded. not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into this courtroom for an eviction, or if they did not come for the eviction, you'll give them a default. Because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right. Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease. Never received it, and as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease. As far as what the original contract was, I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
She might be pushing the limits, and at this point, she could be staring down a contempt charge. The courtroom's tension is rising fast. Meanwhile, the attorney isn't wasting any time. They've called in the property manager, who didn't just show up. They came loaded with documents, timestamps, and a timeline that could seal the case. Things are about to get real. Next voice, next voice. Introducing a surprise witness mid-trial? That's a bold gamble, and not one that always pays off. But here's the real contradiction. If you don't believe in the court's authority, why are you turning to it for support with subpoenas? You can't pick and choose when the system works for you. Next voice, next voice. Let's set the record straight. What you're talking about isn't called constructive possession. The correct term is constructive eviction. That happens when a tenant is forced out because the conditions are so bad. The place is basically unlivable. But here's the catch. It only applies if you actually leave. And since you're still living there, that argument doesn't really hold up. Next voice, next voice. That wraps it up for today. Judge Washington has set a follow-up hearing, and next time it'll happen online. If this recap helped you make sense of it all, go ahead and hit that like button. If it didn't, no hard feelings. We'd still love to hear your thoughts down in the comments. And don't forget to subscribe and turn on notifications so you never miss the next courtroom twist.